Thanks for having us here in your office. You guys got this beautiful studio space.
We appreciate you coming here. We just moved in a little bit over a year ago. Very nice space. It's 21st century office. We really enjoy it.
And the reason we're here today is to talk about what you do here at Stark and Stark and what's potentially on the minds of a lot of people that we interact with in our business. So typically shopping center owners, retail real estate owners. And I had reached out to you a couple months back around the time that Rite Aid had first announced that they were going to start the bankruptcy process. We were getting a lot of inquiries from our clients asking us what we should do. Mm-hmm. And our knee-jerk response is always call an attorney. Mm-hmm. Like that's number one. And which we should clarify.
Should be call Tom Onder and Stark and Stark.
You're an attorney, but you're not our listener's attorney. So our advice is do your own due diligence and have your own counsel. Like that's kind of my asterisk to this conversation. So we had the Rite Aid bankruptcy. I reached out to you saying like, hey, if we've got a client who's got a letter or is potentially worried about what to do in this situation, what do we do? And it's not just Rite Aid. There's other retailers. It's happened in the past. It'll continue to happen in the future. You know, we've got the Kmarts of the world, the Toys R Us's, which we were just talking about, the Blockbusters, the
Party City.
Party City.
I could list, over the last 2 or 3 years, like the folks that we've been involved in different debtor retail bankruptcy cases. We represent mostly, landlords, shopping center owners. Myself as head of our shopping center and retail development group, I've been doing this type of work for probably about 20 years or so. We're always happy to talk with people on, what their rights are when a debtor files for bankruptcy because, quite frankly, Dave, it's, funny when like either you contact me or somebody else contacts me. Most people just don't really know the bankruptcy process and what they should be doing, what they should be looking out for. And we're happy to chat with folks and kind of, give them advice and represent them to protect them in the bankruptcy case. Because it is a little bit arcane when you find out that a debtor is filed and you realize, well, I can't, sue them. I can't go after them, but they owe me money. What am I supposed to do? What are they going to do with my lease? And so we're always happy to chat with people and to discuss kind of what a good game strategy is. And I think that's one of the big things with us, with our landlords that we deal with and shopping center owners, is what's your game plan when they file for bankruptcy? And what should you be doing proactively to get ready for the bankruptcy and to protect your rights throughout the course of it?
Let's talk about that. So if you're a shopping center owner and you've got hypothetically a Rite Aid as one of your tenants in your shopping center, and you hear in the news that they're going to be filing for bankruptcy, what's the first thing you do?
So I've had this question asked to me by a number of owners, and the very first thing that I say is, one, find out if they filed or not. If they have not filed, you want to take a look at your accounting and also to make sure that they're in compliance with the lease. So are there any covenant defaults, like things that they haven't done besides payment of rent that they're supposed to do? And so I always tell folks, I'm like, listen, if they have not filed yet, but there's a concern that they're going to file, you should immediately send out the appropriate notice that's under the lease, either for payment default or for covenant default, to protect your rights.
So let's talk about covenants. What would be a covenant that you would see in a lease? Would that be something like staying open 7 days a week?
So staying open
the property.
Yeah. So maintaining the property. So sometimes we'll get a landlord will contact us and say they're not really taking care of like either the trash services or they're supposed to make certain repairs to the shopping center, the parking lot. They haven't done that. They're closing early. Those are absolutely things in which you want to send out a default notice or notice early on. And the reason that you want to do that is, it's like that old saying of like, the squeaky wheel, the squeaky wheel in a bankruptcy setting, usually gets taken care of. And so when a debtor files, they usually have a time period in which they know when they're going to pull the trigger and actually file that bankruptcy petition. So you as an owner could be in a spot where they're not telling anybody when they're going to file, but they know that they're going to file. Say like
it's coming down the pipeline,
and so
something's going to happen.
Yeah, and if you're a landlord and you exercise your rights by going ahead and sending that default out, that could put you in a position to where you can proceed with that next step, which is an actual enforcement mechanism, like filing a thing like an eviction complaint. And so, like in New Jersey, if they don't pay, generally a landlord can just go ahead and file an eviction action really the next day. In New York and Pennsylvania, it's a little different. New York, there's certain notices that have to go out. So again, coming back to the issue of sending out that notice, to get yourself set up to be able to try to enforce things, you should really send out those default notices early on and stay ahead of them. Because what it does is sometimes the debtor they know that by the time you get to the hearing, that they're not ready to actually file bankruptcy yet. But what they have to do is they may have to work with you, and you may get yourself paid up, as opposed to some other landlords who could be a month or two behind, and when they file for bankruptcy, they don't have to pay that amount right then and there. So again, enforcing, your state court remedies is absolutely, critical, I think, for any owner.
That's a great point, because I've heard from some owners, they're coming from a defensive position where they're saying, I'm going to wait and hear what the bankruptcy court decides to do. And then after that, I'll make my decision on how to proceed forward. But you're suggesting go on the offense right away.
Well, and that's because they haven't filed yet. So if they've filed, then it's a totally different ballgame.
But
if they haven't filed, but they keep saying, they're going to file, or you get somebody who writes blog posts like myself that has a list of, I'll call it possible filings based on data that's out there, and they've not filed, you really want to proceed with your state court efforts to make sure that you're that greasy wheel, because you may wind up getting yourself paid and brought current by the time that they file for bankruptcy. Now, if they file, there's a thing called the Bankruptcy Code's automatic stay, where you got to stop everything you're doing. Yeah, you do not want to do anything. You don't want to try to collect against them. You don't want to try to do any enforcement actions or anything without first consulting a bankruptcy attorney.
So at that point, you're at the whim of basically the court's timeline.
Correct. And you have certain rights, though, as an owner, as a landlord, where you can proceed with your counsel to get, certain abilities from the court. But again, you can't just do it ahead on your own.